set for Vybz Kartel hearing and changed the Bail Act. And the Bail Act now comes into effect, says you can't get bail. If you never got bail before, you can't get bail while you're on appeal, waiting on your appeal, or as the judge says, the clear language, the determination of your appeal.
Good afternoon, I'm Milton Walker. Welcome to TVJ's special coverage of a habeas corpus application on behalf of Vybz Kartel, whose given name is Adidja Palmer, Sean Storm, Campbell and Andre St. John. This today was not a bail application. Let's get that clear.
Welcome viewers and subscribers to Jadil Entertainment. Thank you for being here. All new viewers, click the subscribe button. Well guys, this video is all about Vybz Kartel and his co-accused who got denied bail at the Supreme Court, guys. In this video guys, we have Isat Buchanan laying out the reason why Vybz Kartel and his co-accused did not get bail, guys. And in this one guys, I really want to stay tuned to get to really understand this case, guys. So please stay tuned.
Today was the ruling of the habeas corpus filed from as early as sometime in April, or as early as sometime in May, May, as early as that, filed on behalf of Adidja Palmer, aka Vybz Kartel, Sean Campbell, and Andre St. John. The habeas was filed after serious research, consideration, contemplation of what is certainly the applicant's belief. When my client says to me, clients, plural, says to me, under what law am I being detained after the apex court, the highest court in the land, the Privy Council, makes an order that the convictions should be quashed, meaning they are no longer convicts, they're cloaked in the presumption of innocence, and that the matter will be remitted to the Court of Appeal to determine whether there should be a trial, and it should be done so expeditiously. From the date of the judgment, March 14th, and today being March 30th is almost, I'm going to say 3 months. I'm not too good at math, but March to April is 1, April to May is 2, so 2 months. Yeah, 2 months. I'm glad I tried to do the math. You know, when you're counting in a maths exam. Yeah, so to May 30th is about that. And that's a long time. In fact, legislation in England gives you about 2 months to consider retrial, something about 112 days maximum. Yeah, I do the math, because when I do my exam, it's some you do it. The calculator will tell you a lie. Don't trust technology. You say, I look good on TikTok and look good on see me in a real life. Yo, the people almost mob me downtown. Because I can't control him fans them almost tear off my garments. It's a good thing they don't know where my apartment there. Anyway, and I have to say this because it's so interesting. Interesting for the simple fact that what I discovered is, one, the decision today was initially taking place in courtroom 9, but the media was there. They represented in recognition of the importance and significance of not only Vybz Kartel, but the significance of this case and what has happened to one of our national treasures and his fellow friends. I'm going to put it like that. And as a result, the court was delayed significantly because there was a shout out to court administrator and with Tamsi Bailey, who is the registrar, who considered and had compassion and practicality along with the inspectors to move the court, because you would never knew COVID was ever in Jamaica, and we were moved to the Chief Justice Court, courtroom 1, very big spacious court where Justice Thomas puts out her judgment on the habeas corpus. She did find that there was no lacuna in the law because naturally the Parliament and the Senate, they amended the law in November 2023. This is after the date was. In essence, one of the things, and when you're trying to appreciate law, one of the things that jump out at me was when the judge said that the Privy Council must have known that the legislation was amended and as a result would not have made an order to keep them detained. So the absence of the order would be as a result of the Jamaica legislators contemplating that somebody who commits murder should not get bail and should remain. And that the charge from long before I was a lawyer still is in effect by some, by interpretation, which I have instructions to test elsewhere, and that will be done. So in essence, the habeas corpus, they're saying that although the conviction is quashed and although the Privy Council is the highest court, the appeal is not determined, and so the men will stay in prison until the charge itself, because the charge is revived when the conviction is quashed, and those documents that are on the court's file, it still have ammunition and weight, albeit it is the court that has to give the prosecution permission in the interest of justice to see if they can retry the case. So that said, we proceed to June 10th. What I will say is it's the law of the land, and we simply have to go to June 10th to determine the issue of retrial. And unfortunately, Mr. Palmer and others will have to wait until that time and a determination. So when June 4th comes, let me tell you now, so nobody run me down and chase me to my car and all of that. When the 14th of June comes, it is the court that has the power to say, I'll think about it or deal with it and consider liberty as according to Justice Thomas. It is that court that has the determination of liberty, even though the parliament would have legislated in November 2023 that they have no jurisdiction to offer bail in the circumstances. And so the liberty of the men are not in limbo, it's not at a lacuna, and so what that the conviction is quashed, they're still charged for murder, and that's how law is in Jamaica. So we have to deal with it or do what we always do when litigants are dissatisfied. They appeal, because the process of justice goes all the way to the Privy Council. If you're dissatisfied at the first instance, the Court of Appeal, and then there. So we will see. If my instructions take me all the way to the Privy Council, that is what will have to happen. I did find that she took a lot of thought to it in the short space of time, and the judge ought to be commended for even entertaining the habeas corpus and coming to some ruling and giving us ruling expeditiously. If nothing else has happened in relation to the justice system, is that under the guidance of the Chief Justice, Justice Sykes, and I always have to big him up, when they talk about delay, not so much. And as you can see, here is the 30th coming the Monday after we're in court to deal with this matter. And for people who are not in prison, it seems like, oh, that's just 2 weeks. But if you are in prison, you can appreciate the stress and the continued detention and remaining in abeyance is a psychological experience you don't want to know. Just take it from people who, when them in America and them finish them sentence and then them say go in immigration and try fight for stay America, everybody sign paper and say, me I got my yard because I can't take lock up no more. So can you imagine you have no business with DCS, but them hot and them have to bound by Section 18, as the judge said, to keep you until the court says otherwise. So make no mistake, if COVID come tomorrow and court locked till 2050 and 3012, if that court order don't come, all who is water now, we're all are going to disappear, not be alive anymore, and the order, because it remain on the file, people can't come out of prison. And it don't matter what the apex court says about a conviction being quashed, you just cannot come out until the order from the court saying that you can be released, even though you are not serving a sentence. And the Constitution, from my reading, does not contemplate that, but the judge has made a ruling, and if you are dissatisfied, you have to take it elsewhere. That's the best I can take it, but as I said, the mantra is God and time. And when I say World Boss is free, I maintain the positivity and know that when we deal with the issue of the relevant court, that most certainly, more than anything, that relevant court is the Privy Council. And whether it is that the citizen will get his redress only there, if that's what it looks like when it comes to who you are, where it is, if what it perceived to be. I don't think it's so, but if that's what it is, maybe the true question when we're dealing about what court we need to go to is considering issues like this and what justice looks like in 2024. But for me, the best part of the judge's ruling is when she said no orders as to costs, because men ask Christ when the state I got have to pay because the Privy Council says so, and we don't have to give you back any money. So respect. And as I said, it wasn't a contentious application, and the judge was most helpful in trying to find an answer to what the clients and as well as the defense team believed is a lacuna in the law. And come on, this is Jamaica. Of course, we're still trying to get it right. Blessings on that topic.